Welcome, everyone. This is the South Asia Center, one of the webinars that we're going to have. As you perhaps know, I've taken over the directorship of the South Asia Center about a month ago, so it's also my first sort of public viewing on this platform. Very pleased to have you all and welcome. As you know, the LSE is very interested always in issues of colonialism and its impact on different parts of the world. Today, of course, we're focusing on a very specific topic, which is really quite important, relating to colonial laws and social change. As you know, we'll have sort of speakers that I'll introduce in a moment who will take your questions at some stage later on. You're very welcome to do that. Do please also tweet with the LSE sort of tag. Make sure that you include that at South Asia LSE. Now, we are dealing with a topic of immense importance. It's emerged as an area that is of keen interest to a variety of individuals across the globe. In a sense, you know that certainly South Asian countries have been impacted by British sort of laws and reforms and regulations for a long period of time, and this is carrying on today. There have been changes, there have been evolutions and developments in this light. So we'll hear from some of the experts on these issues, and perhaps also hear a little bit about whether there have been some positive or some adverse outcomes of the changes that we've seen recently. So I'd like now to introduce the major speakers. First of all, I'd like to also say that alongside the South Asia Center at LSE, we are joined with iProbono, which has done tremendously good work dealing with sort of civil society issues where there are legal sort of aspects that they can get involved in and help out with. So very pleased to have Mariam Faruqi, who'll be the moderator, and she will be essentially asking the principal questions that some of which may be coming from you, as well as relating to her own interests and expertise. But I'll introduce now the speakers. So we have Aparna Chandra, welcome. She is Associate Professor of Law at the National Law School of India University in Bangalore. We have Osama Siddique, who is Associate Fellow at the Institute of Development and Economic Alternatives in Lahore, and also a regular attendee at the Lahore Lit Fest, where he sometimes speaks about his own fictional and non-fiction literature. So welcome, Osama. We have Aritha Wikram Singh, a lawyer and director of the Equality Law and Justice Program at iProbono, Colombo. And of course, as I mentioned, Mariam is going to moderate the discussion. So I'll hand it over to you, Mariam, and look forward to some of the discourse today. Thank you.
Thank you so much, Professor Bhimani. It's a real pleasure to join you all here today and just welcome everybody to the discussion on colonial law and social change. As you know, I'm the South Asia Regional Director at iProbono. I'm also a lawyer. And this is the first in a series of discussions we're hosting on decolonization of the law in South Asia. I'd like to start off by thanking Professor Bhimani, Dr. Sarkar, and the LSE South Asia Center for sharing this platform with iProbono. A little bit about us. We're an organization with a mission to enable people to access their rights in pursuit of a just society. We do this by strengthening civil society, litigating for the most vulnerable justice seekers, and advocating for human rights and social justice. We also aim to provide a regional forum for lawyers and activists from South Asian countries to accelerate their work across borders. So it's a poignant time, I feel, for us to be talking about shifting legal frameworks in South Asia. As practitioners, we've all been feeling the strains of ailing court systems across jurisdictions, fraught with pendency of cases, administrative delays on the one hand, and of course the colonial legacy of laws on blasphemy, sodomy, and sedition, for example, that are all being used rather expeditiously by our governments. And I feel that the pandemic has only served to place these issues in relief. So how do we make the colonial, often arcane institutions and legislative frameworks keep up with how our societies have changed and are continuously changing? How do we as legal academics, legal service providers, activists respond to the lived realities and pressing social justice issues in a more equitable manner? So in that sense, I'm just very pleased to share this platform with our three experts who will be unraveling the debate and exploring how decolonization of the law can be a vehicle for social change. And Professor Bhimani has very kindly provided us with our speakers' backgrounds, and I won't go into that at all, but very briefly, Osama's book, award-winning book, Pakistan's Experience with Formal Law and Alien Justice, is a go-to on the topic that we'll be discussing today. Really pleased to be sharing platform with him. And similarly, Aparna's work on law, governance and gender, as well as the judicial process and current reforms in India, are very relevant. She's sitting in Bangalore right now, which is the hotbed of the current criminal reform process, which is going on in India. And Aritha, of course, will be expanding upon the work that he's been doing in Sri Lanka and the current concerns there, particularly in light of LGBT plus reforms across the country. So what I'd like to do before I leave you in the safe hands of our experts, just let you know what we're going to be doing for the next hour and approximately 45 minutes. So Aparna and Osama will each start off by defining the terms of our discussion in the context of their own scholarship. They'll address our understanding of being post-colonial in a legal context. And then I'm hoping that they'll engage with each other in a discussion to elaborate upon why we're taking a regional approach, really, to cover issues from a historico-legal perspective, talk about comparative constitutionalism, empiricism, and institutional reform. They'll then focus on legal issues impacting the LGBT plus communities in the context of decolonization, including a brief look at the decriminalization of homosexuality in India with the removal of Section 377 of the Indian Penal Code 1860 in 2018. Then I'm hoping Aritha will develop this perspective and take us to the particular case of Sri Lanka. He'll provide a constitutional overview in the context of parliamentary supremacy and use examples of advocacy as a tool to decolonize our understandings of the law and accelerate changes within society as a whole. I'm, of course, going to ensure that there's plenty of time at the end for a question and answer session. So without much ado, I'd like to pass the floor to the experts. Osama, over to you.
Many thanks, Professor Bhimani, and thanks a lot, Mariam, for this generous introduction and also for this invitation. I think this is an incredibly important topic, and I think you've laid it out very well in terms of the various facets which we ought to look at. I guess for starters, the not so easy task of defining what is the colonial and what is the post-colonial. I mean, this is a rampant and ongoing and rich debate. And I want to clarify at the very outset that for obvious reasons, for me, colonialism is not just a certain periodization with a certain very distinct cutoff point, which then transitions you into the post-colonial. On the contrary, quite apart from the historical sort of continuum of colonialism, followed by independence in a lot of states, I think it's also important to think about all kinds of continuities, all kinds of hybrids, certain kinds of assumptions, perceptions, attitudes, which permeate a society. And I think, it becomes incredibly important time and again to look at the work of Frantz Fanon in terms of the psychological impact of colonialism. How, when you look at post-colonial bureaucracies and judiciaries, and you look at certain assumptions about societies and certain classifications and stereotypes of people, how those attitudes and assumptions permeate legal judgments, legal process, the direction which legislation takes, the prioritization of certain things. Similarly, I think equally relevant still remains Edward Said's work in terms of orientalization, in terms of othering, in terms of, it's quite remarkable how the criminal tribes, which were created as a classification during colonial times, have not completely gone out of fashion. And a lot of, you talk to police officers and all that, there are certain things associated with certain castes and subcastes. So that sociological aspect of the law as it actually happens. So it's a far more complex phenomenon than just talking about a certain period followed by another period. Now, my own work is from two particular perspectives. So I want to clarify where I'm coming from. So from a purely black letter very textual analyst of law, I would like to think that over the years I've evolved into what I would describe as a sociologist of law. Because the most time I spent looking at other disciplines and their take on the formal legal system. And it's quite remarkable because if you look at the literature on colonial law in India, by far the largest sort of contribution is from anthropologists, sociologists, political scientists, political economists, not legal scholars. And that's a point I'll come to later because that has huge ramifications. So I realized that even to understand what was happening under colonialism, I have to look at all these other disciplines and what their take is. And they say some very different things and some incredibly important things. And the other sort of perspective I have is that of an actual practitioner since 2004, because I got involved with the policy side or the law reform side of things, which gave me an opportunity to work with multiple projects, which is a phenomenon in itself because this was foreign funded reform. But it provided very important sort of insights and entry points into how exactly reform takes place, what the priorities are, who the players are, and what goes on. Now, my sort of larger perspective on this entire question about the colonial law and the impact or the continuing impact on post-colonial sociology, society, access to justice, rights protection, I think four sort of broad parameters which really interest me is this entire dichotomy of subjecthood and citizenship. And we would like to think that that's a major transition, right? As we move towards a post-colonial, independent, constitutional ethos, how does the transformation actually take place from a notion of subjecthood to citizenship? The other thing which I explore a lot in my book is this entire notion of displacement. And my sense is that there was a whole lot of displacement which took place because of colonial law, not only in the normative sense, but also in the sense of how people do things on a regular basis, right? So Bernard Cohen makes this very important insight into the fact that the psychology or the psyche of a people can be understood in terms of understanding how they resolve their disputes. So when we transition to an adversarial system, to a formal legal system, to a court system, I think it becomes incredibly important who got left out and who got fairly sort of subsumed and entrenched in this system. Now, counterintuitively, if you read the great Urdu short story writer Munshi Premchand, even at the beginning of the 20th century, he's pointing out that the colonial courts have been corrupted, they're incredibly slow, and there are multiple classes of people who have become leeches, so to speak, on the system. So the formal legal system in its own right is a very interesting phenomenon, how it manifests itself in the post-colonial societies, because it took on very different trajectories. And I think it's also a fallacy to think that the British actually replicated the system they had in Britain, in India. That's not true. And hopefully we'll get a chance to elaborate a bit on that further. The third thing, which is incredibly important to me, and that becomes very relevant in the context of rights protection, which is what we're going to be talking about later, is alienation. And that became even more apparent to me. That's not something you see in the statutes, that doesn't necessarily come through the judgments. That's when I tried my hand at empirical work and started talking to a lot of litigants. And it turns out that simple things like language, distance from the court, the complexity of the law, financial status, gender, caste, ethnicity plays a huge role in terms of access. And these are the inequities which were perhaps always there, but have gotten augmented because a lot of the traditional systems got displaced. Now, I'm incredibly interested in Aparna's take on this because when I say traditional and when I say conventional, that's a loaded term, and that's a term which can also be politically manipulated. And I'm completely open and cognizant as far as that is concerned. And the fourth, I think, really important and very obvious factor is, of course, the economic extraction dimension of law. Because at the end of the day, we have to realize that a lot of the governance and a lot of the laws which were introduced in this part of the world were essentially to uphold and maintain and sustain a certain status quo when it came to economic extraction. And not only that, it sort of resulted in certain kinds of political economy arrangements. To give you a very obvious example, the land holding pattern in Pakistani Punjab, the fact that large tracts of lands were allocated to the military for commercial use or as private reward for loyalty, and the kind of impact that has on the post-colonial political economy in terms of access to land, in terms of concentration of power, in terms of the centralization of the role of the army, is just one example of the continuities which you see from a certain legal framework, which we have to look at not just from the framework or the concept of a system to resolve disputes or enforce contracts or go to court, but also as something which is the underpinning of an entire political economy of power. So I think those are the sort of most important things. And I'm waiting for your cue if my time is up in terms of laying out the contours of my sort of paradigm in terms of how I look at things. Should I stop?
You've got another couple of minutes if you'd like to continue.
Okay.
Yeah.
So I guess for me, the two most important things when I look at the literature on colonial law and all that is the current ahistoricity of how the legal fraternity or the people who actually look at law reform in South Asia look at laws. So I think there's a lot of ahistoricity considering the wealth of literature which is now emerging, which is exactly highlighting the kinds of issues which I'm talking about. And the other is the decontextualization of it. And the decontextualization of it emerges both from not looking specifically at local realities. And I'm not an advocate here for particularizing everything according to the context and not looking at universal norms. I'm making a different point. But the also this decontextualization is also significant here, especially in the context of Pakistan, because a lot of this law reform process is bankrolled and defined by international organizations, IFIs, international governments, and that sort of then creates a separate issue of transplantation, one size fits all, and looking at certain kinds of things like contract enforcement, land rights, but not looking at other kinds of things like labor rights and environmental rights. Those kinds of mega significant policy choices. So I'll stop here.
Thank you. Fantastic. Thank you. And over to you, Aparna.
Thank you. Again, thank you for inviting me for this discussion. The danger of going second is, of course, that the first speaker might have said everything you want to say, and then the only thing you can say is, I concur with my co-panelists. So by and large, I should say I concur with everything that Osama said, but that since that has never stopped me from speaking, I'm going to speak nonetheless. So I think I agree with Osama that we need to think of decolonization not as an event but as a process. And when I use the phrase decolonization, I'm actually referring to decoloniality of the law, which I'm borrowing from Latin American scholars of colonialism, who draw the distinction between decolonization, which they essentially use to refer to the transfer of political power to previously colonized populations, and decoloniality, which is the dismantling of the power structures, the hierarchies, the hegemonies, the assumptions and attitudes that sustain and continue to sustain the unequal power relationship between the colonizers and the colonized. And I'm particularly interested in decoloniality in knowledge production about the law, and decoloniality in conceptualizing state power. So both are interconnected, of course, and I'll briefly explain that connection. But I also want to think about the ways in which the rhetoric of decolonization gets deployed as a political tool to entrench through the law the very same power structures that decoloniality aims to oppose. And I'm referring particularly to recent law reform efforts in India, and I hope in my remarks now, but also in the discussion going forward, to explain some of that. But first, on decoloniality in knowledge production about the law. Now, decolonizing academia is, of course, has been a site of significant debate in countries like the UK, as it should, since we still have not had a full reckoning of UK's history as a colonial power. But equally, coming from my location as an academic in the global south, in technically in a post-colonial state, the need to decolonize academia in the post-colony remains an unfulfilled imperative, because our understanding of law, of legal theory, of the role of legal institutions, the shape of legal systems continues to be foundationally shaped by the global north. And any deviance from the global north as a point of critique requires an additional burden of justification So in a sense, the template is set by the global north. That's the default setting. And to the extent that we want to customize our own system, we need to have a good reason for it. But decoloniality teaches us to be wary of universal abstract truths. So perhaps I'm being a bit more radical than Osama in saying that we should be wary of universal abstract truths or of a single way of being. Decoloniality teaches us that universalism can itself be a technique of power, pretty much as Osama was saying. Just as the universal model of civilization was used to justify colonialism, so also today universal models of development or universal approaches to the rule of law, universal approaches to models of good governance, transparency, contract enforcement, so on and so forth, can and have become new techniques of power. And decoloniality would force us to confront these as techniques of powers, as global techniques of powers. Decolonizing knowledge production also forces us to confront the process by which these norms came into being. They came to be thought of as universal, and thereby to understand them as products of very particular social, political, historical, material processes. In that sense, decoloniality then asks us to confront the idea that difference does not amount to deviance, which was very central to establishing and maintaining the colonial state. And that who gets to speak, who gets heard, on what subject, whose views counts, whose life experiences are the norm, should all be explored and excavated in the process of decolonizing the law. So then instead of overarching grand theories, one should then focus on contingent, grounded, experienced reality. So how we theorize the law? How do we theorize the practice of the law? How do we evaluate our legal practice and our legal institutions? These are all implicated in the decoloniality project. It's not just about getting them rid of their colonial origins. And one particular example of this from my own area of work, which is constitutional law, comes to mind, and this applies to law more generally, and that's the rise of global South constitutionalism. Again, something that we'll probably touch upon more in our discussion. But in a typical constitutional law class in India, one would begin the study of constitutional law with Dicey's introduction to the study of the law of the Constitution. And of course, no one mentions his position on colonialism as a way to contextualize his ideas. So very much the acontextual approach that Osama was talking about. Or the scope of judicial review, for example, takes the US as a template, and we need to justify departures from that template. But global South constitutionalism, on the other hand, compares countries with similar history, similar material circumstances, to learn from each other on how to address or how not to address similar problems. So how do we think of the role of the judiciary in the context of large-scale impoverishment, graded and structural inequality in society, massive state failure, endemic corruption, limited state capacity, extractive and exploitative market structures? These are the background conditions in which a theory of judicial review should emerge. So that's decoloniality of knowledge production about the law, about how we think about the law, how we theorize the law. The other linked issue, of course, is decoloniality in the context of state power. The decolonization movement was, of course, in large part directed at self-determination, at the political freedom to self-govern. So state power was, of course, central to the decolonization process. But as repeated invocations of the phrase colonial continuities reminds us, decolonization is, of course, not at an end. So decoloniality is not only about transfer of power, it also involves reimagining the relationship between the state and the individual, again, echoing Osama, what it means to be a subject versus what it means to be a citizen. And at least this was definitely a huge concern for the Indian Constituent Assembly, which, though it took on the administrative structure of the colonial state, sought to reconfigure the relationship of the state with the individual by subjecting the state to the constraints of fundamental rights, by locating the source of the legitimacy of the state to the will of the people. At least that was the ambition of the Constitution. But we also inherited the legal structures of the colonial state. So in India, Article 372 of the Constitution continues the application of all previous laws unless repealed by Parliament or struck down by the courts for violating fundamental rights. So a large part of the legal edifice remains the same, and the institutional structure remains the same. So the same judiciary, which applied and upheld the same colonial legal system, is now pressed into service primarily to apply the same laws, especially at the lower levels, at the trial court levels. And why was this edifice put in place by the colonial state? To maintain the power of the colonial state, basically to preserve the state against opposition, to maintain law and order, to implement the rule of colonial difference, as Partha Chatterjee would call it, the ruler being rational, superior, civilized, the ruler being irrational, needing discipline, needing to be tamed, needing to be controlled, etc. Colonial law was also used as a laboratory for legal experimentation. So large-scale codification of penal laws in South Asia, for example, was a test case for similar codification exercises back in Britain. So the logic of the legal structure within which we operate today was not designed to address our specific needs, experiences, or ethos, but perhaps more importantly, they were designed to subject us and to keep us subjugated to colonial rule, with the understanding that the protection of law and order, the preservation of the state, is the highest aim of the legal system. And that sits at odds with the ambitions of the Constitution, which sees us as free and equal citizens, and which sees the state as bounded, and which ties the legitimacy of the state to the will of the people, not to its own self-preservation, or not only to its own self-preservation, I should say. So there's a tension here that needs to be resolved. And we're in this perpetual cycle of law reform to bring the legal edifice in consonance with the Constitution. But this is where I think there's certain dangers that arise. One, the decolonization project can very easily fall into nativism, the idea that anything of colonial origin is bad, anything that is indigenous is good. And there's a very short road from there to science denialism, to reifying and justifying very problematic social practices. So that's a concern that's always there, and that's a concern that we're witnessing in India today. Second is that the rhetoric of decolonization is very powerful, but that power can be channelized to create new forms of hierarchies rooted in the same logic of biological determinism, or graded hierarchy, cultural superiority, that were part of the colonial project. And I'm thinking of the Hindu right in India that claims that India was colonized actually 1,000 years ago, referring, of course, to the arrival of Islamic rulers in India. And for them, the decolonization process is a project of reverting to some kind of imagined glorious Hindu past. But they're also using and co-opting the logic and the emotive power of decolonization. So that worries me. And the third thing that worries me is that in law reform, when governments claim to be decolonizing the law, what is it that they're moving to? So India is currently undertaking a massive law reform exercise, not based as much out of Bangalore, Mariam, but based out of New Delhi, located in my previous law school, which is NLU Delhi, and that's come in for very severe and very justified criticism. But the larger point is, who's benefiting from these law reforms, who is losing, who's driving these law reform projects. Again, I'm echoing what Osama said. Governments have very little incentive to give up on colonial forms of state power because it enhances their own power. And especially as governments turn authoritarian and they seek to instrumentalize law for preserving their own power, law reform aimed at decolonization without decoloniality could end up putting us in a worse off position vis-a-vis the state than colonial law did. So it's very important, I think, to make a distinction between decolonization as a process of removing that which is of colonial origin, and decoloniality, which is that about transforming power structures and the continuing hegemonic control of colonial structures and imaginations, including the colonial state structure. So more than origins, it's about existing power structures. And but these are the concerns that I have with the current link between decolonization and law reform. I will just stop by saying that every critique that I made of decolonization and about colonial law could very well have been said by the current Home Minister of India, because in last year he was saying in kicking off the law reform exercise around the Indian criminal laws, he said that these laws were made made for the benefit of the colonial state, to protect the stability of the colonial state, and they enshrined a master-servant relationship between the colonizer and the colonized. And this is a near verbatim quote. But of course, given the nature of this current government and the kind of authoritarian politics that it has unleashed, what the invocation of decolonization is doing in this law reform effort is deeply worrying. So, so this is where I am. I mean, the emotive power of decolonization is, of course, true and present. The need for decolonization is present, but I also have a certain ambivalence about the deployment of the rhetoric of decolonization in present day India.
Thank you, Aparna. That was really helpful to sort of elucidate the discussion, and both of you have really set the terms to move forward. And what we thought would be interesting was to have a discussion. We're so limited now on Zoom and rare opportunities to actually meet in person. So hopefully you can use this forum to generate an interactive discussion. And Aritha, please feel free to let me know if you want to sort of join the discussion at all at this point. But really, Aparna and Osama for the next 20 minutes are going to be elaborating on the importance of taking a regional approach. And I think it's interesting that, we've got them sitting across borders, but really such a nuanced understanding of each other's jurisdictions. So without much ado, sort of moving onto that conversation, which we thought could start by taking a historical legal perspective, really. And I think Osama had taken us back to the psychology of colonialism by mentioning Fanon and Said. And Aparna, you've sort of talked us through history as well. So I'll leave it to you both to really kick off this part of the discussion. Osama, I think you're on mute. Yeah.
If I may respond to the multiple really insightful points made by Aparna. And before I go a little bit more into the history, and I quite agree that the sort of the distinction between decoloniality and sort of decolonization is incredibly important, and also to the bifurcate the knowledge part of it and the institutional power part of it. I think that's a very important insight. Now, the interesting story is that about 10 years ago or 11 years ago, there was a very interesting thing which I noted, which is that the leader of the Swat Taliban, who sort of created an uprising in one northern part of Pakistan, the local Pakistani Taliban, and sort of occupied a territory and said that they wanted to impose Islamic law. His primary statement about what his ideal form of justice is was exactly the same as the statement made by the Chief Justice of Pakistan, which was exactly the same as the statement made by the head of the World Bank Group operating in Pakistan. So that creates a remarkable paradox. And the statement was that we want speedy justice. So it's interesting that at one level, while we're talking about theorizing and knowledge and norms, a very sort of basic and immediate and sort of sensed and felt notion of justice and courts is that we should get disputes resolved quickly, right? So it's very interesting. I probed, but I could not find anything normatively which was of any depth or any rigor in the Taliban statement, or for that matter, the other two statements. So the challenge here is that while I completely agree that it's incredibly important to approach reform from a standpoint which looks closely at contextual reality, which looks at continuing sort of notions of exploitation, some of which may be actually dating from colonial periods, others may be augmentation or even new creations, because society is dynamic. It carries on changing. And since ostensibly we are operating under a constitutional ethos, that framework is still there. The second point I wanted to make was about the universality of norms. And, so I think Pakistan is a very interesting example because there has been a lot more direct pressure, because when you're borrowing money or when you're being given grants, the World Bank has a very particular notion of what rule of law means. And as Aparna said, there are all kinds of international best practices, lists, rankings every year. Now, to a certain extent, you also don't completely disregard them, because if a ranking says that India and Pakistan, in terms of civil dispute resolution, are amongst the bottom 10 countries in the world, that tells a story. And there is a story of backlogs, and there is a story of hundreds of years of backlog and the everyday experience of the person in court. But then there are also all the other things which he spoke about, which are completely ignored. But to go back to history, I think it's incredibly important neither to demonize it nor to romanticize it. And so I think, I don't want to come across as someone who's saying that the Contract Act of 1872 is a hegemonic thing which should be undone. And I'm completely cognizant of what Aparna is saying in terms of the problematic potential of using this as a slogan and perpetuating other kinds of orthodoxies and hegemonies. Now, the Pakistani experience has been somewhat different in the sense that we've had our brushes with this notion of Islamization in the past. We've had Islamization of parts of the law, especially personal law. We've had, particularly under Zia, certain provisions which were introduced which remain controversial. But about 15, 20 years ago, there was also this sense that some of the judicial leadership in Pakistan is trying to create an alternative normative framework on the notion of Sadiq and Amin and that's still there because Article 62 and 63, under which Prime Minister Nawaz Sharif has been removed, is from Zia's time and has this Islamic sort of piety clause kind of a feel to it, and hugely opposed and hugely controversial, but still used. But by and large, you would see that the mainstream Pakistani legal system has not been Islamized, and any judicial trend within the judiciary was short-lived and died out. And some of the really big spokespersons for this thing at the most spoke about coming up with new terms like replacing justice, equity, and good conscience from the colonial times and things like that. But that jurisprudence didn't really take off. So that's, for us at least right now, not an immediate concern when we have this. But I completely see how that has become a concern, and that shows how rapidly things can change, right? How in 4 to 5 years, your preoccupations and your apprehensions are different. Going back to history, as I was saying, let's not demonize it, let's not sort of romanticize it. I think there's a huge need to demystify it. Now, in terms of popular approaches, you'll either find some people saying we need an Islamic system. If you ask them what it means, they can't elaborate. Or they'll talk about constitutionalism, which is secular, or all kinds of things. But some people you will still find, and I'm sure that's true across the border as well, who still romanticize about this thing called the colonial law. They say, no, we don't trust the natives to do it still. Credit goes to the British that they actually came up with this statute. Who would have done it? Now, I think that the notion here is that there is some kind of a monolithic, harmonious, uncontroversial process through which the British gave laws to this part of the world. It was quite the contrary. I mean, not only was it very, very different in different parts of India in terms of what the local imperatives were, and I'm talking about the period before the Grand Codification, before 1857. I mean, they started off rather meekly and rather abjectly trying to find something called the original constitution, grand wisdom of the Hindu Pandits, and the great normative Islamic law, which is uniform across the board, which is not the case in the Islamic world. There are variations. Then there were lots of translations and misinterpretations, and some of those translations and misinterpretations were deliberate because they were trying to prioritize, give power to certain classes, a particular gender in society at the cost of others. So it was very much of a predetermined process. Then there were all kinds of hybrids, which they had with Islamic law and colonial sort of jurisprudence. So my point is there are all kinds of experimentations. There's all kinds of guinea pigging. There is a huge discontent with the law as it existed in England. So they were doing all their experimentation here. There is this huge impact of utilitarianism and all kinds of maverick civil servants, including the Lawrence brothers, who are doing all kinds of experimentation. There are all kinds of capitulations. There is demonization of Islamic law as horrendous, and yet they replace it with punishments which are even more horrendous. So this is a process rife with contradictions, rife with all kinds of ambiguities. And then you see the grand sort of codification project, and codification is the rage globally. And then you see all these laws coming into play. Now, if you think about society and how dynamic it is, not just from the colonial to the post-colonial, but also in terms of what all has happened over the last century in terms of new classes emerging and economic interests and contestations and sophistication and technology, you will find that our judiciaries and our legal discourse is multiple decades behind that, right? So now they're trying to grapple with free speech and cybercrime and how to use. Pakistan sort of blocked TikTok a week ago. They've revived it, because the fundamental reality of free speech in this day and age and what technology means and what kinds of economic incentives are at stake, it's so difficult that, but can you hear me? Because I can see that my internet connection is a bit unstable. Okay. So my point is that I think this throws up all kinds of challenges in terms of what our conventional legal approaches to reform are, which are very much steeped in some ways in in sort of looking at things from this particular perspective. So you'll find that there's far less emphasis on regulation. There's far more emphasis on penalization, right? So we try and our entire attention is around an FIR and then a court trial and adjudication. The world has moved on in terms of how do you regulate human behavior, societal behavior, what the notion of penalization is. And, so talking about knowledge production, this entire sort of Foucauldian project of the knowledge power nexus, which Cohen talks about, Foucault talks about, how prisons were constructed, how information was actually used for control. You will find a lot of agencies in our part of the world still operate in the same way. So a big challenge is to strike a balance between trying to talk about modernity in terms of moving to more sophisticated, more humane mechanisms of regulation, and yet at the same time also resisting the pressure of the international financial institutions who are just concerned about land rights as they exist, not going into what this property right regime is, what is it based on, what does it defend, who are not concerned about labor rights, who are not concerned about environmental rights. So I think it's a dual challenge. At one level, we are talking about modernity when it comes to that kind of outdated, outmoded, warped conventional thinking. At another level, we're trying not to get sucked into a kind of a model which they prescribe to Bolivia, Pakistan, Cambodia, and it doesn't work at any place, right? So these transplants are mostly, if you look at rule of law reform reports and sort of assessments and taxonomies, they're by and large unsuccessful. And I think they're by and large unsuccessful precisely for the reasons which Aparna has been pointing out. So I'll just stop here for a second.
Thank you. That's really helpful. And Aparna, I wondered if you wanted to step in from a sort of comparative perspective. And I think Aritha has a couple of points to make as well. It'd be fantastic.
Right. No, I think, just, as Osama was speaking about penalization as the primary mode of governance as opposed to regulation, and the value of the FIR, and, the move very quickly from the moment there is a justice demand to shifting to a criminal law model of delivering justice, which has only intensified in India, at least in the last 15, 20 odd years. There might be a longer history and trajectory to it, but it seems to be intensifying in the last couple of decades. Just resonated with everything that's happening in India. And I was also struck by the cyclical nature of some of the conversations of law reform processes, right? So precisely the kind of legal experimentation, codification, the idea of a sort of a universal just, whatever your paradigm of justice might be, but universal system of justice, which could be placed in India, which could be then placed in Africa, which could, the same regulatory structure that could be placed across the world, is being replicated now through these rule of law projects, indices, your set of constitutional advisors who go on to new countries and, give them a set of structures of what makes, for proper constitutional governance. And so that's both very cyclical, but also, again, based on the understanding, based on some underlying assumptions about the universality of norms of justice, universality of norms of governance, but also an understanding of law itself as being disconnected from society, right? Like law being a technical enterprise. Yeah. And this is something that you see in India at the moment, the rise of policy think tanks, or think tanks that are involved in the law reform process, who think of law as a technical, and law reform as a technical enterprise of drafting, right? As opposed to being so deeply connected with society that you need a grassroots sort of understanding of how the law operates on the grassroots level for you to think about law reform. And so just the imagination of how law reform occurs currently is very much a similar idea, and it follows a similar trajectory as colonial law reform projects, because again there you were thinking of these sort of standalone models that you implemented in one state and you could implement in another, and you didn't really need to have a connection or a connect or an understanding even of how things operated on the ground for you to be able to, I mean, our countries were partitioned by someone who had no understanding of the ground reality of the border. So I mean, that kind of technology of law reform seems to be just, replicate of current law reform seems to be replicating the same modes of thinking and same modes of governance that we haven't really confronted in our colonial past. So I think, I mean, just echoing the idea that Osama started with, that having this sort of decontextualized understanding of law reform and dehistoricizing our own legal processes has led us to this moment where we think of law in ways that does not connect it to social change, that does not connect it to the ground level sort of social situation that the law is going to be acting on, and that perhaps creates the sense of both the sense of alienation but the sense of disconnect between the people that the law is supposed to govern and the institutions of the law, and leading to all sorts of sort of manifestations and state failures and institutional failures that are endemic and rife in this part of the world.
Thanks, Aparna. And in fact, you'd mentioned earlier, you talked about who is actually heard and who do we listen to in this whole process. And I thought it would be really interesting for both of you to just touch upon empiricism, legal databases, collection of data, academic research, how it filters down to the people we're actually making the law for. If you could both elaborate on that a little bit, that would be really interesting before we move on to talking a little bit more about the specific changes in relation to the LGBT community. Thank you.
So, no, I think that's very important to explore. And once again, I think it's a lose-lose situation in the sense that at one level, we are trying to couch and define everything in a technocratic way, thereby depoliticizing law or making it apolitical, which is really a disempowering process because it is a political phenomenon. And unless you recognize that, you're not going to be cognizant about who's consistently losing out. But having said that, even things which ought to be purely technocratic, we are not doing by and large. And I'll give you two examples. So I mentioned in an earlier conversation, the case flow management kind of a thing, which is a purely technocratic thing. It's an efficiency model whereby you look at court systems and you try and make them more efficient, make them more predictable, make decision-making data-based. And certain positive developments may have taken place, and Aparna can comment on that as far as India is concerned. But in the past, when I've spoken to friends and colleagues across the board, the situation was not very dissimilar. We've had incremental law reform commission sort of interventions, but nobody has holistically looked at how a place as big as Punjab in Pakistan is being governed. So, the mechanics of administration, there is a technical part to it. I'll give you another example. I would venture to think that it's not very different. But if we look at the typical crime scene investigation in any of our countries, it's not even in the 19th century, not just in terms of budgetary allocation, but in terms of protocol. So at fundamental levels, certain things can actually be fixed purely through process changes, which are not politically contentious. And yet we do not do even that. Now, coming to data, the problem we face is that historically, and once again, I think I work with all sort of sectors of the criminal justice sector, all the components of it, but also civil justice. The judiciary is definitely far behind when it comes to things. And I think that's very important to sociologically examine the institution. Who are these people? Where they come from? Why this blind spot? Where's the accountability? And so the data which is actually collected, first of all, is highly aggregated. So it's not even, so when I talk to social scientists and other disciplines, and when I talk to political scientists using data, and when I look at lawyers, we are sort of centuries apart. And that is the same for the judiciary as compared to other people. So I think there's a huge gap. in terms of even understanding. And as a tactic of reform, pushing reform, I've discovered that if you have data on your side and you've made the effort, you're far more persuasive because they don't have an answer. You come to them with any other idea, they say, oh, we've made rules on this, we've made rules on that. But data can be incredibly potent. The other problem, so the data collection system is very poor, and this is despite multiple interventions. They're not data savvy. They're not willing to hire people who can look at data because they feel that the judicial work is this very confidential work. If you want to access data as a researcher, unless you know friends in high places or you have leverage or it's a foreign project, they'll hide away those files. So I've done a lot of empirical research. I've done a fair bit over the last 10 years, and the most difficult part is to actually excavate that information, because there's no centralized. And that's a huge issue that creates issues of opaqueness, of accountability. And it goes without saying that for 100 million people in a province, you may be making policies in terms of prioritization of judicial resources, which are completely blind, which are based on, I can imagine that it's also always based on policy choices, right? Which kinds of cases do you want to prioritize because you don't have resources for everything. But it turns out that without that data, you're blind. There's another fallacy, and that fallacy is that somehow you have a silver bullet, a magic pill, which is some technological thing, right? They don't really understand technology either. So they think that you can get a software and the software will resolve everything, not realizing that it's what you put into the software. And also that unless you remove systemic and process issues, the system is going to be cluttered in any case. You may be able to capture that, but you're not resolving the issue. So I think I've discovered a lot of blind spots when it comes to that. And I think there is a much greater need for there to be also public demand for these things. I think the public discourse on judicial reforms is highly underdeveloped. Even our journalists don't understand things at a deeper level, right? And so I think it's incredibly important not to look at just the supply side of things, but to look at how nuanced and how forceful for the demand of justice is, so that when people get asked questions, what are your disposals, which category, at which stage do you have cases cluttered, things like that for which they don't mostly have answers, there'll be a pressure to start accumulating that information.
Thanks, Osama. And I'm going to move the discussion on a little. Aparna, I don't know if you had anything to add to that on the...
A couple of points. I mean, everything that Osama, you said, you could have been speaking for the Indian judicial system as well. I just want to add perhaps a couple of points, a couple of very short points. First is absolutely the technocratic aspects of institutional functioning need to be taken into account, and there is the political, there is the technocratic, and one shouldn't confuse one for the other. But even what counts as technocratic could be context dependent. And just because you use the term efficiency, I just wanted to say something about one form of judicial reform exercise that was in vogue till a few years ago, seems to be buried right now. I don't know when it might get find another resurgence, was the idea of India having judicial impact assessments. And the idea was that before a law is passed, Parliament needs to do a judicial impact assessment to figure out what is the likely impact of legislating that law on the judicial system. And then unless you make appropriate allocations for budgetary allocations and resource allocations for it, you cannot pass that law. And of course, there's a long history of judicial impact assessments as a political project, for example, in the US, where Indian policymakers were drawing that idea. And it's a very conservative idea. The idea is to stop an increase in statutory rights through linking rights to questions of efficiency. And in India, when we were borrowing the idea, there's a need for judicial reform. There's a sense of strain and a sense of crisis in the judicial system. But in thinking about what that law reform should look like, one is, again, looking at templates of what, sexy ideas that coming from different places, without thinking of both the, who's pushing that idea, for what reason, in what context it is working in the place that it is coming from, and what impact it might have locally. So you're not thinking about it in terms of data, you're not thinking about it in terms of context, you're not thinking about it in terms of power. You're thinking of it only as a technical efficiency exercise. So this idea of sort of politicizing the technocratic aspects, I think it's very important to do that. Second thing I just want to say, that again, in terms of data, the one data that courts in India do seem to collect is disposals, right? And everything that's evaluated, because that's the only data point that you have, or very often the only data point that you have. So much of judicial reform processes in India become about disposals. And disposals are not the only metric on which you can judge a judicial system, as I'm sure we'll all agree. But the pressures and the kind of pressure that it puts on judges to just get done with cases and process the cases and get them out of the system is quite immense. I've worked extensively at the National, I used to work at the National Judicial Academy, work extensively with judges, and I see that at the trial court level, that this disposal orientedness is really misaligning the incentives, the disincentives of the system. So I think, again, just that the technocratic can end up shaping the political and the policy in so many different ways that we need to be cognizant of.
Can I just quickly add one sentence? Because this disposal point has been the bane in so many ways as the central sort of parameter. And just to add further, what I've sort of also and my colleagues have discovered is that it can be manipulated so easily, right? So disposal, you can have, so you're creating perverse incentives, right? So judges can start looking at the really easy cases and start ignoring the contentious ones, which may actually be very important from a societal perspective. Secondly, disposal doesn't mean that the judgment has been written. They could still keep sitting on it. Thirdly, there is no notion of quality of justice. We don't know what kind of justice it is. And fourthly, we're not even talking about process justice, right? So what happens during those 11 long years along the way before disposal? So I think it's a fundamentally flawed thing. And so that goes on to show that to the extent that they are looking at data, it is such a problematic and outdated sort of exercise.
Thank you. And this actually makes me realize that we should actually be having a whole conversation on data. And Aparna, I know that a lot of your new research is based on quantitative data relating to the Supreme Court. Aritha, you've been waiting very patiently, and I know that you had something to add to this part of the discussion. Please share that with us, and then we'll move swiftly on to the next part.
Thank you, Mariam, and thank you, Osama and Aparna. Now, I just wanted to add to what Osama was speaking about, which I found was very interesting, is the codification exercise during the colonial period of customary laws and practices, and the impact of that codification exercise. Sri Lanka was a European colony since the 1500s, and there was an extensive codification exercise during the Dutch period in the 1700s. One of them was the codification of laws which affected the Tamil community. And despite it now being 2020, these laws which affected the Tamil community, which were codified in the late 1700s, have still not been changed or amended. So what has happened is that we have literally frozen that society and their customary practices to what they were 300 years ago. And of course, there was a very patriarchal society, and the patriarchal practices of that society continue to be reflected in modern day application of that law. We also see this issue with the Muslim marriage laws, which are also codified during a colonial period, and which still have an incredibly damaging impact on especially women. But in Sri Lanka, we also have another set of personal laws which govern the central region of the island. And that codification exercise also happened during the colonial period. There were some changes after. And that part of the island was actually a more matriarchal society. And when you look at how the law for that area was codified, actually is quite gender balanced. especially when you look at the provisions on the dissolution of marriage, it was extremely gender balanced. And even the entry into marriage was gender balanced in the sense that a husband, a male partner could join the female's household, or the female partner could join the male household. And in fact, in an earlier form of the codification of these laws, because it was a customary practice in that part of the island, only women could have multiple husbands, but men couldn't. That right was given to women at the time, before it was changed later on. But my main problem with continuing to blame colonization for the sort of for the fact that these laws have been frozen in time, some for 300 years, is that countries like India, Sri Lanka, most of the subcontinent, we have been independent for over 75 years, or 3/4 of a century. And there has been a number of movements, at least within Sri Lankan society, especially women's rights groups, within these communities to reform these highly patriarchal and extremely discriminatory laws. But when you have failed to reform laws which were codified, which only codified customary practices, over the last 75 years, that kind of failure, how much can we continue to blame colonization when we've had ample time to address these patriarchal laws? And we must also understand that the colonial empires at the time, the European empires, they were patriarchal themselves. And their codification process, the laws they were introducing reflected those patriarchal systems. But they have continued to reform and address patriarchy in those societies. But we have failed to do that in our societies, and we continue to freeze our communities for for the practices they had 300 years ago. So I mean, don't you think it's time we stop blaming colonization and start blaming ourselves?
So apologies, Arith, I'm actually going to interrupt you at that point and cheat a little bit, because I'm going to use a question that's come in from one of the participants to take off from the point you've just made and transition us into the next part of our discussion, and for want of time. So we've been asked, why has there been a great reluctance to remove from the penal code offences against Victorian morality that have long been abolished in the UK, but is still preserved in the colonies? So exactly your point, Aritha. And perhaps one of you can explain what's happened in India, for example, with the removal of Section 377, and then we can transition to Aritha's piece on Sri Lanka and LGBT plus advocacy that he's going to be sharing with me. So Aparna or Sama, if you'd like to take that forward.
Sure. So 377 of the Indian Penal Code basically criminalized sexual intercourse against the order of nature. And when it was legislated, when it was codified, Macaulay said, this is an offense that we shouldn't even name, because just naming it is going to create all sorts of deviant thoughts in the minds of people. So it criminalized offenses against the order of nature, but it was always understood as criminalizing same-sex sexual intercourse, in particular men having sex with men, because you needed a condition of meeting the sort of the requirements of the section was, of proving the requirements of the section was that penetration had to be proved. This was the framing of 377. Now 377 was struck down by the Delhi High Court in 2009, but in 2013 the Supreme Court reversed the judgment of the Delhi High Court, and that led to, there was already a movement around equality, equality around dimensions of gender and sexuality, but the the Supreme Court judgment of 2013 particularly spurred a movement, and subsequently in 2018, the Supreme Court finally struck that provision down again. But having said that, I do want to point to two fault lines which go back to the point of who gets heard, who does not get heard. There's been a lot of criticism of the movement for for decriminalization of 377, in that that it's taken up so much of space and so much of the focus around questions around questions facing LGBTQI plus communities, that this was a marginal provision. It's given it the stature, the 377, the stature and importance because of this movement, but it's not really dealt with the lived realities of people who are really at the front lines of facing police brutality, which is, for example, trans persons. Who were most affected by 377, but continue to be subjected to police brutality, and there's not been enough space in the movement for their concerns, that this was very much an upper class driven project, and that is why not enough focus has gone into the transgender persons laws, that this is a law reform process that's ongoing. The rules have this is not an area of my expertise, but to my understanding, the rules or the draft rules were recently notified, that there is serious concerns with respect to these laws, but there's not enough movement and momentum around these, only because it does not impact the most high profile of people who are part of the 377 movement. Right now, there's a set of petitions pending in courts in India on same-sex marriage, and again, there is a whole critique of these petitions, that these are misaligned, these are mistaken priorities, that you do not want these issues to be taking up space when people are fighting for their very existence. So that there's a resource allocation problem. I'll stop there.
Thanks so much, Aparna. That's really, really helpful to provide us with the basis for the next part of the discussion. And obviously the Section 377 judgment has had reverberations across the region. And that's what Aritha will be telling us a little bit more about in the context of the work that he's doing in Sri Lanka. So over to you, Aritha.
Thank you, Maria. Thanks, Aparna, for giving the kind of background on 377. And what, talking about colonial laws and decolonization law, I think one of the most incredible moments from that judgment was, it was such a beautiful poetic judgment, but also I remember watching an interview by, I think one of the activists who were involved in the case, and this question was asked, is this a Western thing? Is this necessary? And then and also that, India is now finally, recognizing the rights of LGBT people, and his statement was, look, this is not a Western thing. What we're actually doing is we're decolonizing the law, and I think that's very important, especially for us in the subcontinent, which have such a long history of being ruled by colonial empires, and have really failed, despite independence, to repeal and to decolonize a lot of the laws which have been used to control, to marginalize us, and to subjugate us to a specific political system. And Sri Lanka is a very good example of the impact, the negative impact of a lot of these colonial laws, especially around LGBT issues, where we have the corresponding sections 365 and 365A of the Penal Code, which criminalize carnal intercourse against order of nature, but also criminalizes gross indecency between persons. Both these laws are used against LGBT people in Sri Lanka. And unfortunately, the struggle which we've had in repealing, in amending, in decolonizing these offensive provisions is the fact that we don't have judicial review. post-enactment judicial review under Sri Lanka's constitution. We're on our second Republican constitution. We only became a republic in 1972, although we became an independent dominion state in 1948. We're on our third independence constitution and second Republican constitution. And what both Republican constitutions did was that they introduced chapters on fundamental rights, beautiful chapters with all these rights to equality, non-discrimination, etc. But then they all had this provision, these grandfathering clauses in the fundamental rights chapter, which said all existing laws are valid, even if it contravenes the fundamental rights chapter in the constitution. Now, this is quite polar opposite in some ways to the Indian constitution, which does give validity to the existing laws, unless they're found to violate fundamental rights through a court challenge. We don't have that option. And we are stuck between the system of a written constitution and constitutional supremacy, but also competing with parliamentary sovereignty and supremacy. And these two concepts are in conflict in Sri Lanka. And because of that, it prevents us to go for post-enactment judicial review of any offending legislation. Even post these constitutions as well. There's only pre-enactment judicial review of legislation since 1978, which is still a positive step forward. But even that, you only have about 2 weeks after a bill is published in order to challenge its constitutionality and also to challenge whether the law violates fundamental rights. And it is impossible at bill stage to actually know whether a law is actually going to challenge someone's fundamental rights. So this is the struggle we faced with 365 and 365A, which has meant that we've had to work with parliamentarians and government in order to actually have this law repealed or amended. And that's the sort of work we have been doing in the last several years here in Sri Lanka, is working with the various subcommittees, the gender and fundamental rights subcommittees of Parliament, working with the Justice Ministry in order to first educate parliamentarians on the impact this law is having, and then the need to amend or repeal it in the least controversial manner possible. It's been challenging in a number of ways. We've had certain positive developments in Sri Lanka. In 2014, we had a statement by the Attorney General, which is an independent office here, which stated that discrimination against LGBT people was unconstitutional, and that these specific laws cannot be applied in a manner that is discriminatory towards LGBT people. Now, this statement has been repeated by the Attorney General, especially in international fora and in their submissions to the UN, almost like a prayer every year. But despite this constant repetition, emphasizing on the right to equality of LGBT people and the protection from discrimination, when we look in practice, we can see that this is not happening. iProbono our lawyers have been involved in a number of prosecutions in Sri Lanka where LGBT people, especially gay men and trans men, have been prosecuted for same-sex conduct. Recently, just a few days ago, Human Rights Watch released a statement exposing how these people, who are the defendants in the cases which iProbono lawyers are representing, where these defendants have also all been subject to anal examinations and vaginal examinations to prove their homosexuality as evidence for the prosecution. In one of the cases, we had the court mandating sexual health screenings of the accused, despite all of them having participated in consensual relations. And one of the accused actually had an HIV diagnosis, and this was revealed in court and published in court documents before it was actually revealed to the person affected. So these sort of really abhorrent practices have been taking place, despite the Attorney General making statements saying that there is no discrimination and that such discrimination is unconstitutional. And we have actually written letters to the Attorney General saying that there is a conflict in what you are saying, and the fact that the police and your office is party to prosecutions of LGBT people. So you can't go to international fora and say one thing, but actually in practice, you're doing something quite abhorrent. We've also just recently written to the Justice Ministry highlighting what is effectively state-sponsored rape and sexual abuse of LGBT people if you are forcing your fingers and utensils up someone's, anus or vagina. It's rape, it's sexual abuse, and it's committed by the state. So one of the other things which we have been doing here as well, because we have to pretty much carry out a hearts and minds exercise in order to convince people that these laws are bad and offensive, that they're not part of Sri Lankan culture or history, they're actually foreign, white, imposed legislation, and that we need to decolonize these laws, is that we've been running a media campaign working with the largest media house in Sri Lanka, and actually what was seen as a very conservative media house. So working partnering with them to advocate on LGBT issues, and primarily to share stories of LGBT people. I think something which is common to our South Asian subcontinental culture is this emphasis on family, on community, on values based around the family. And therefore, what we did was we shared stories, video stories of LGBT people together with their families and friends. So we partnered a mother and a gay son, cousins and a gay cousin brother and a sister. So we did this kind of partnerings where they were able to share their story, and they would be obviously they share their story with their family member, and really emphasize the importance of supporting someone who's LGBT as part of your family values. So using that traditional narrative and ideas around family values and other values to emphasize that LGBT people are also part of your family, and they must also be loved, respected, and accepted. So I'd like to share the sort of launch video which we created for this. We created in the languages which spoken here, but we also did an English version of it. And so, I mean, I like to share it with our audience and with Osama and Aparna and Al-Noor, so you can see how we launched this campaign.
ගොඩක් කට්ටිය කියන්නේ මෙහෙ ඉඳපුව කරන්න හොඳ මෙහෙ රටවල් තියෙනවා වෙන රටවල් වලට යන්න. ඔබේ ජීවිතේට අනන්තවත් බය දැනලා තියෙනවා. කිසි කාල සීමාවක් තිබුණා කිසිම විදිහකින් ඔවුන් මාත් එක්ක සම්බන්ධතාවයක් කරගන්න නැති. Support equality.
So, hello?
Yep, thanks, Saritha. Go ahead. Yep.
So that's a sort of video we did to launch the series, and we had actually planned it to be just a 1 month long series. It ended up being over 3 months because of the stories that we were sharing, the traction it was getting, and it really had it had such a positive impact on mindset change, in the sense that our viewing was very high because we were on these major social media platforms, but run by the biggest news groups in the island. It was also during a lockdown period, so everyone was at home and had to watch and was on social media and online. And when we looked, we were constantly monitoring the commentary and what people were saying. And actually, it was a huge shift from earlier news articles on LGBT issues shared by the similar media organization, where there was a lot of negativity. But once we started sharing people's stories and emphasizing the importance and putting it together in the context of family values and Sri Lankan values, the narrative and the commentary became much more positive. And people were just asking questions like, why is this criminal? Why do we have these laws here? What is wrong with, being LGBT? So those are the kinds of questions that were coming out. And actually very interestingly, what we also did at the same time was the Daily Mirror group. Sri Lanka was also entering into a parliamentary election at the time in August. And the Daily Mirror group started a political series to question all the different contestants and the major, possible ministers and parliamentarians. And what they did was actually to host that series, they hired Bhumi Harendran, who is a very popular trans activist. She's a very successful trans woman, and she became the face of the political series. So the first time actually a trans person took such a front stage, and then she was put to ask general political questions from all these candidates from all the major parties. And with all of them, she also asked them questions on LGBT issues and rights. And it became much more difficult for especially some of these right-wing parties, to openly tell her, the narrative which they were using earlier was LGBT people have mental illnesses, they're against our culture and all of that. But here we had Bhumi wearing a sari, asking them on LGBT issues. And they couldn't tell her to her face that, LGBT people have mental issues, that they need to be criminalized, because she was staring at them in the face. She was an LGBT person, was there in person in front of these politicians who usually go and attack and spew out homophobic and transphobic things. And that changed their mindset as well on it. They realized LGBT people are not an other. They're not against our culture. They're not a Western import. In fact, it's these laws which penalize him that are Western import, and that it's time to change them. And we've had extremely positive strides since then. We're now working with government on a law reform program on a number of issues. And we are hopeful that there will be some commitment in government in addressing these issues.
Great, thank you, Aritha, for sharing that sort of particular example for us and answering one of the questions from the floor as well. And what I'd like to do now actually is I'd like to take some more questions from the floor, but it would be great if we don't have the time, obviously, to take this discussion as far as we would like to. And I guess that's a disclaimer that I'm making already in a conversation that we've had earlier, is that it's impossible to cover all the points that we want to make. But an interesting question that's come in, and I'd sort of give this to all of you, is going back to this whole idea of decolonization and social change. So many social justice issues at the intersection of gender, religion, caste, and privilege fall back on ideas of democracy and secularism. So how do we ensure that attempts to decolonize the law that we've been talking about today, institutions, social attitudes, don't conflict with universal human rights values? Would one of you like to take that question?
So can I try and answer that question, but also sort of connect it to what Aritha just sort of presented? Because I think one thing which comes out of it is how important it is for us to look at each other regionally in terms of strategies and what works and what doesn't. So uh, three or four things which I want to quickly say. So in Pakistan, I think there's been tremendous progress on transgender rights over the last decade. And that's a story which needs to be studied by myself, but I think others as well, as to what strategies, what coalitions, what approaches work there, how a bunch of concessions in various judgments ultimately translated into a law in 2018, which at least chips away at some of the fundamental issues to do with identity, which then of course has a direct bearing. Once you are identified and you're given identity, can you be a claimant to various constitutional rights? Um, the other thing which I want to quickly say, because that also touches on decolonization and decoloniality, is that must have noticed that even in the video, the colonialism motive is still there. It's relevant, but I think, as Arita himself said, that different parts of the island, there were different customary laws. So I think and what they did was that the patriarchal was preserved, and in the matriarchal they corrected it to make it balanced, right? So if anything, they took it to a harmonious balance, but only because it was. But what I want to say is that I think we need to also appreciate the fact that South Asia is many different places within the countries as well, right? So when we say that, why do we keep blaming colonialism? First of all, it's not about blame. It's about understanding and deconstruction and demystification. And I'll give you a couple of examples why it's relevant. So you look at the federally administered tribal areas in Pakistan, FATA, which has recently been mainstreamed. This is the buffer of land separating Afghanistan from Pakistan, governed under a very sort of repressive colonial regime, and now being mainstreamed. And I'm currently actually working on a project which is looking at how to make this mainstreaming happen. Now, you have to understand that when I compare Lahore, where I'm sitting, it's eons away in so many ways from FATA, right? So the colonial imprint is much deeper. And you have to understand how to start doing things. So now here's the dilemma which I face, right? So much as we don't necessarily want the jirga, which is the traditional council of tribal elders to resolve disputes, which is obviously patriarchal, there's a lot of demand for that simply because of the simplicity of the process, not perhaps on behalf of women and others. But what do? Do we take the mainstream Indian Pakistani formal court system and give it to them? Because that's not a boon either. We've not been able to reform it either. So my point is that in a lot of places, the strategy of reform will have to be very fine-tuned to the constraints and the circumstances on the ground, because otherwise it's not going to work. The other problem is that the attitudes are still very much so. Saadat Hasan Manto, the famous Urdu short story writer, was tried for obscenity multiple times. And it's fascinating, as many times in the colonial era as in the post-colonial era, under the same law. So you have, the judges are changing, but the approaches are not changing. My point is that I think more so than we think, the psychology, the approaches, the sociology of a lot of our cardinal institutions are quite outdated. We sort of imagine that we are in these modern metropolises and things have moved on, but you're appalled and you're amazed when you have those conversations. Now, in terms of the universal frameworks, while it is incredibly important, I think, to be to be wary of these universal best practices, I think it's very important to abide by the universal sort of Declaration of Human Rights and covenants. But I tell you what doesn't work, where it gets shoddy. So one particular project came in and they thought that the best thing they can do is to translate the Universal Declaration of Human Rights into Urdu and circulate it in this rural area. Nobody's going to read it. Nobody cares about it. What matters over there is whether the police reforms take place, which has an impact on people's lives daily. So it's important how you use the normative and you embrace the constitutional, and you also look at the cultural and come up with just solutions. But it's also incredibly important that it does not become an empty slogan, which a lot of times these international covenants do become. But you're right. I mean, in many ways, the path forward has to be connected with whatever progress we've made, internationally speaking, in the universal human rights movement. Given the fact, but while being cognizant that these laws also in many ways, as we know, are the outcome of a certain process which is dated, and white men were involved basically. And so third world approaches to international law, third world approaches to human rights is a very real thing now. which is important to look at. But yes, we have a lot of benchmarks now, which can be tremendously useful as tools and as normative frameworks.
Thanks. And Aparna and Aritha, do you have anything to add to that?
Yeah, just two short points. One, responding to the current question, just to say that some of these instruments are so abstract in the way that they're framed, and they have to be, because they want to be, speaking to the entire world, that those words have very little meaning, and the meaning is given in particular contexts. So just to say that the Universal Declaration of Human Rights is sort of either your benchmark or your backstop, it really makes very little difference, because we live, or at least particularly in India, we are at a moment where very, very anti-secular practices can pass off as secularism, as a new mode of secularism, right? So I mean, so similarly, equality could be redefined in ways that they don't match up to some ethos of equality. So just to say that I don't think international human rights necessarily is going to give us the protections that we're looking for. That has to come from a grounded people's movement. So I mean, I don't think law is the solution necessarily to what is a political current, and that reform work. I was very struck by Aritha's point. Because they don't have post-enactment judicial review, they have to engage with parliamentarians. Because we have post-enactment judicial review, so much of our focus in our advocacy turns to the law and turns to the judicial institution, as opposed to engaging with parliamentarians, engaging with the people, and making law reform work. And as disenchantment with court processes has set in, you see some amount of turning back to the people. And I think the anti-CA movement, in some senses, this is the New Citizenship Amendment Act, which led to a lot of protests across the country, with people reading the preamble, using the preamble, thinking of the preamble as an instrument of protest, preamble to the Constitution. I think that was in part because people have very little faith in institutions. So you fall back to the people themselves, and that's not a easy answer, right? That's a messy answer. That takes time. That's not giving you the win that a judicial decision will give you. But ultimately, the protection of secularism will not come from I would be very surprised if it comes in the long run from the judiciary. There might be small gains and incremental benefits, but for a political tide will be stopped only by politics. And just on the point of Victoria, I actually had a question for Aritha. To what extent is the invocation of colonialism, when you're talking about our Section 365 and 365A, is it strategic, or is it grounded in history, in the history and sociology of pre-colonial society? Was there actually acceptance on the basis of equality of people of all genders and sexualities, or is it today an emotive device to get people to sort of to accept LGBTQ persons on the basis that their disenfranchisement and their marginalization is a product of colonial imagination?
So one of the things which we've done over the last few years is actually to also make historical references, to make references to historical references about LGBTIQ persons in Sri Lankan society and culture. Sri Lanka is predominantly a Buddhist society, and Buddhism has always been very accepting of the variant degrees of expression of sexual identities and gender identities. And within Buddhism, Buddhism recognizes that gender and sexual orientation is can fall for different individuals on a spectrum. And even in Hindu philosophy, and even in progressive Christian and even Islamic philosophies, there is this idea, the idea of equality of all persons and non-discrimination is actually entrenched in all the major religions and cultures of Sri Lanka. And when we look at historical references to LGBT people in society, they have always it has never been made, it was never referenced in a negative manner, and always emphasized the cultural contribution of the LGBT people and sometimes their higher social status in sort of royal courts, for example. So it's the criminalization is very much, and the stigmatization is very much a colonial input to our society. And we keep emphasizing that, and we need to emphasize that, because if it weren't for these laws, we wouldn't be in this position. And we can look at a very good example with Thailand, for example, which is 95% Theravada Buddhists, very similar, which is this type of Buddhism practice in Sri Lanka. And in fact, it was Sri Lankan missionaries which went to Thailand and established Buddhism there. And if you look at Thailand's treatment of LGBT people, it is very progressive and very inclusive. And unfortunately, and then we look at Myanmar, which was, and Thailand was never colonized, right? So it was never part of the empire. But then we look at Myanmar, which was part of the British Empire, and the treatment of LGBT people is very different to Thailand, despite them also being 95% Theravada Buddhists. So it's very, so you can really create a narrative that it is colonization, which has led to the marginalization, criminalization, and stigmatization through criminalization for LGBT people. And there is very strong empirical evidence to show that.
Thanks, Aritha, and thanks, Aparna, for that question. I'm going to ask two questions that have come in from the floor, both quite different. Now, one interesting and sort of linked into what you've just been talking about, which is based in the Foucauldian idea of subjugated knowledges. But they've asked, what do you think about the meta-narrative in politics that has caused dualisms and binaries in law, which is used to legitimize indigenous elites who create vulnerable classes by dominating relationships? So it'd be interesting to hear your comments on that. And then Aparna, I have a question for you on polling after this one, but I think I'll wait. I'll let you guys tackle this one first. Anyone want to take that on meta-narrative in politics?
Aparna, do you want to go ahead, or shall I? Okay, so I mean, I'm not quite sure from which particular sort of ongoing academic narrative that point may be coming from, but is it an argument being made about the creation of local hierarchies and then using them as an agency for further perpetuating classifications and groups like that?
I think that's the context that we can put it in. It hasn't been contextualized in that sense, but that's
okay,
how
so,
I would read it.
So what maybe it's asking something different, but what brings to my mind is within the sort of codification project and within the sort of knowledge documentation project. I mean, I think, and when Aritha was talking about this commonality between the three countries and colonization and the approach to LGBT people, I mean, look at caste. I mean, caste is another very good example where a fair amount of work has been done, how approaches to caste hardened during the colonial period. So there was arguably a lot more flexibility to be moving between castes, or let's say the identification of people according to those categories was not as frigid as it became because of the colonial project, because they needed to classify people in order to do that. Looking at another sort of colonial project, which has to do with knowledge and then classification and rigidification and creation of local sort of elites, you have the agrarian caste and the martial races, which played a huge role in terms of identifying certain groups of people who were loyalists, who were then anointed as the martial races, and those who had resisted actually colonial rule were sort of categorized as the non-martial races. I mean, the Bengalis are a good example, even though a lot of the resistance actually against colonialism was in Bengal. The entire sort of social engineering which took place in Pakistani Punjab with the canal irrigation project was based on similar social engineering. So I think there is in Punjabi and a lot of other regional languages, a lot of epic tales about the people who actually defied or fought against colonialism. And you hardly find mention of them. 70, 80 years down the road, people are now excavating those popular tales, legends, poems. The people who perpetuate themselves time and again in the elected assemblies of the post-independence Pakistan are exactly the castes and the tribes who were actually given a prominent role. So that tradition actually perpetuates itself through families, through castes, through certain social classes, through landholding elites, through the military civilian sort of hybrid. So in that sense, and they are the ones in many ways who are also opposed to couching this entire conversation as a project to decolonize either knowledge or the power process, because they are the ones holding the power. Right? So a lot of them will actually make the argument, what are you talking about? We've had so many reform projects. Look at all these incremental changes we've made, So much as there is a need not to just play a blame game and to introspect, I think it's incredibly important how, which is why I started off by saying that for me, it is not a historical period which is discrete. It is complex arrangements, frameworks, sort of perpetuities, which you see carrying on, which need to be sort of examined, not just technocratically, but also politically and sociologically.
Thanks, Osama. Aparna and Aritha, did you want to add anything to that?
No,
Okay, so
I'm
going to actually move back very quickly for our last couple of questions to the question.
I have one thing to add,
oh yeah,
Mariam.
sure, go ahead. Yeah.
When we, there have been few questions and concerns raised by some of our audience on whether decolonizing is going to be actually emphasizing some of the patriarchal or discriminatory or elitist cultural practices some of our societies may have, and whether in this decolonization exercise, how do we make human rights practices, knowledge on human rights, which are universal in some ways, more indigenous, an indigenous understanding and an indigenous evolution of these values. And at least from a Sri Lanka context, and I can see this is also similar in India and maybe even Pakistan, is that I find the debate and the discourse around fundamental rights and what it means to be a citizen and human rights is very much done in the English language. And the courts responsible for making judgments and pronouncements on these rights and expanding these rights also run in the English language. Now in Sri Lanka, from the Court of Appeal onwards, the cases are heard and judgments are made in English, but only about 10% of our population have a comprehensive understanding of English. And therefore 90% of Sri Lankans, and in Sri Lanka, it is only the Supreme Court which is jurisdictional fundamental rights. So if you've had your fundamental rights violated, you cannot go to your High Court. You can only go to the Supreme Court, and only the Supreme Court can make any pronouncement on the Constitution. So what we are seeing is that actually the institution and the responsible for ensuring the rights of Sri Lankan citizens, this entire framework is running in a language which 90% of citizens actually don't understand. And we saw this issue in 2019. We had a constitutional crisis towards the end of 2018. And during that crisis, there was cases in the Supreme Court challenging certain actions of the president. And pretty much for about 60 days, the only thing in the news was this constitutional crisis. And in January 2019, soon after this crisis, there was a survey done by one of the organizations iProbono works with to gather people's understanding of the Constitution and fundamental rights. And what really surprised us, this was an island-wide survey, was that the vast majority of Sri Lankans did not know that we had a constitution and that there were fundamental rights which were protected in that constitution. This is despite that that for about 60 days, the entire national narrative and debate was going on about the Constitution. And that's because a lot of it was also happening in a language, and these judgments were being made in a language which actually people don't comprehend and understand. And I think we have this problem in South Asia because a lot of our superior courts run in English. And therefore, there's a disconnect between these institutions which are determining our rights and which are which are expanding on them sometimes, and actually the people who cannot comprehend the language that these debates are happening in.
Thanks, Arakat. Actually, I had a comment from someone who's joined this conversation. Who sent what, not knowing that you have a constitution, just came up on my WhatsApp. But Aparna, we have a question for you actually, from someone who works with iProbono on specifically, I think, on your point on the language of rights, and if change is going to, you refer to the CA protests in India, and if change is going to come from outside the court system and parliament, then shouldn't we take snapshots of public opinion? Do you know of any innovative use of public opinion polling, for example, that you can see coming from the activists, etc., quantitative data being generated?
Not to my knowledge. That is not to say that that's not happening. It's just that that's not something that I have followed. But I will say that we live in this era of fake news and fake data, that I'm just very suspicious of polling data. The one kind of polling data that we do have are opinion polls and exit polls around elections. And the frequency with which they get things wrong, I think, is only surpassed by the frequency with which the weather person gets the weather wrong. And so for that reason alone, I think I would be suspicious. It is also the case that I mean, and let me use this to make a larger point about empiricism. As someone who does empirical legal work, I also think there are limits to empiricism, and that we should be cautious about empiricism, particularly given the kind of data politics and the kind of surveillance systems and surveillance capitalist systems that we are currently witnessing. There are things about people that perhaps we should not know, and asking people about their opinions on political issues in a context which is so fraught, where the state and social structures are such are fairly oppressive, I think is a matter of concern. So I would think, I mean, this is just a small point about polling, but it's a larger point about data and what gets collected. It might make for better laws if we know everything about everyone, or it might make for better advocacy if we know everything about everyone. But perhaps we shouldn't. I should say that the government proposes to know people's political opinions through the strange device of the National Health Data Mission, where they want to capture as sensitive data people's political opinions. Don't ask me why, but that's the policy that's up for debate right now.
Thank you for answering that. But we have about 9 minutes before I hand back to, or perhaps a bit less, before I hand back to Alnoor. So Alnoor, did you have a question? I thought I saw your hand up.
I did have a question, though I didn't want to crowd out other questions.
No, go ahead. Please go ahead.
Okay, very, very good. My expertise is not in civil or criminal law, but I have an interest in governance systems and accounting regulations. And one of the things we find there is that there is an element of colonization that takes place where you try and standardize approaches to communicating things. That standardization typically comes from Europe or North America. And it kind of piggybacks on the idea of the economistic rationale for the colonization that takes place. And economics itself attempts to subscribe to scientific notions of the right and the wrong. And so my question to you was, to what extent, I mean, you've spoken a little bit about, technocracies and the natural order of things that is embedded in sort of regulations and sections. And I wondered to what extent you find that there is that element of colonization and tensions that arises from, you know, the Brits brought certain regulations in, and we've kept on, but that kind of relied on something much deeper, which had to do with the acquiescence or celebration of science. And so to what extent do you find that in your examples, that there is that subscription to science and yet that rejection of the nationalistic element that gets embedded in regulations?
Please go ahead. I saw Aparna and Osama both nodding. So which one of you would like to go ahead first?
So in some ways, you know, I have to step one step backwards, because we do, from a practical standpoint, at least in the reform sort of process we try and push forward, mention time and again that the people who colonized us actually introduced these reforms in the 1980s, right? So you are subscribing to a notion of how the court functions, but those people themselves have changed it, right? So in the 80s, there was a whole bunch of commission reports in the early 90s in Britain, because it turned out that the system itself was getting choked there. So there is a level at which maybe it's paradoxical, maybe it's contradictory. It becomes important to leverage your argument by looking at these practices because they seem to work in a certain way, in terms of certain efficiencies and certain process efficiencies. Because what you're up against is so obsolete and so opaque and so problematic that you want to at least get that fundamental clutter out of the way before you even have the luxury of thinking about how to decolonize or decolonate it further. Because, you know, you're looking at somebody who's presiding single-handedly over the fate of the litigation of a population of 100 million people, working with 19th century approaches and technology. So first you try and drag them into the 20th century, and then you try and talk about contextualization and things like that. I mean, I could give you anecdote after anecdote, since I've worked with multiple chief justices, about the variety of sort of responses you get when you try and pitch the argument at the level of sophistication at which Aparna was talking or you are talking, right? So I think you have to rationalize your expectations very, very quickly. But I think, having said that, there is no substitute for the fact that a lot of these solutions have to be indigenized. Now, connecting what I'm just saying to the question earlier asked about data, I can understand the apprehensions which Aparna is talking about the government trying to dig out information from people about the system. Now, we have a lot of these things as well called perception surveys, which are important at a certain political level. But I think one fundamental thing which we haven't spoken about is the state of the academy. You know, we constantly assume here government in a centralized position to be doing all this. And I find it also comical that we expect the judiciary to reform itself. Nobody does that, right? Unless there's an external pressure, or there is politics, or there is a movement, which Aparna is talking about. Now, as an academic, I started doing empirical work about 10 years ago. And I realized that you have to very quickly, and that perhaps, Al-Noor, goes to your point as well, you have to very quickly modify your methodology according to what you're doing. First of all, I realized that purely quantitative responses don't really help you. Secondly, if I talk to the economists and the political scientists, every single survey I've done would be thrown into the dustbin, because such is the exactitude of their randomized sample mythology that, you know, when I talk about what I'm trying to do, and yet at the same time, I mean, my sort of standing joke with the economists is, you have great methodology, you ask abysmally bad questions. And they say to me, you have wonderful questions, you have poor methodology. So we try and strike a balance. And I always talk to the econometricians and other people about randomization, about all kinds of things, trying to understand how to do it. But turned out that the most insightful feedback I got in the Lahore District Court over 15 days in December 10 years ago, working with 25 students from LUMS, was when we managed to actually get into the realm of the anecdotal. Because you know, so it was almost a combination of the political scientist survey and the anthropological, you know, and the ideal thing would be actually to follow case files and to follow an entire case trajectory. But that, of course, is very difficult and expensive, and you know, there are all kinds of issues. So here we were standing in the Lahore district courts, wary that the lawyers may come and take us to task because we're talking about their performance to the litigant. They are already intimidated. They already, as was pointed out, don't understand English or the Mughal Urdu in which the proceedings take place. And yet you're trying to win over their confidence. So we actually made up the methodology as we went along, and the next time we did it differently. But I can bet with you that it might work in India, or they may have to make other adjustments. It's very, very different from the prescribed method of doing this. And yet we found a lot of very interesting insights, which then became the basis of further work and which also reflects in my book. So I wanted to quote that example to say that, yes, there is always the endeavor to be more nuanced, but there are also the very practical limitations of your audience and your interlocutors, and to the extent to which you can push the envelope.
Really interesting. And I think that whole notion of pushing the envelope is something that's really come out of this discussion, and how we can sort of use cross-disciplinary methods, data collection, advocacy, storytelling, as you said, collection of qualitative data and different types of tools to really take this sort of whole project of decolonizing the law and effecting social change forward. We've got 5 minutes left, and in an ideal world, it would be great if our speakers could sort of, I wanted to give you a little bit more time, but if you could sum up in a minute before I hand back to Al-Noor, but wanted to thank all three of you for a really compelling discussion. Thank you. Osama, perhaps you could go first if you have any last points you wanted to make.
No, I think this has been a fascinating conversation, and it proves to me time and again, and that has been one of my imperatives in whatever little capacity I work over the last couple of decades, to really have greater dialogue with the neighbors. I think there is so much to learn from each other in terms of strategies and approaches, and every time I talk, I learn, and there is a few things to share. And I think we have a lot more in common, obviously, than we have with a lot of other people. So if benchmarks, parameters, frameworks have to come, they will come from us and they'll apply to each other. As it is, there are very few of us doing this. So I think we need to we need to join together and do it together.
I think I think it's perhaps a lingering legacy of colonialism that an Indian, a Pakistani, and a Sri Lankan are meeting at a UK venue, and perhaps the one good thing to come out of the webinarization of academia and activism is perhaps that we'll have more opportunities to meet. I just want to make one point that I think connects both to what Osama said and the question that Al-Noor asked, which is that data was also central to the colonial enterprise. And so there was a lot of data collection, a lot of documentation, a lot of bureaucracy, and that was a way of sort of knowing the colonial subject. So of categorizing the colonial subject and slotting them into places, and if you didn't fit in, then you were deviant, so on and so forth. So surveillance, Osama mentioned the Criminal Tribes Act earlier, with the whole documentation that went behind it, the filing of FIRs when a child was born to a person from a quote-unquote criminal tribe community, so on and so forth. And so that data was very central to knowing the colonial subject and gave it a veneer of science, right? So there's a lot of interesting work happening around around medical jurisprudence about knowing the body of the colonial subject, and looking at it through a quote-unquote scientific lens of what passed as scientific knowledge at the moment about the colonial subject, and on that basis trying to understand how to deal with this colonial subject. So this is the years of the I'm making things up, but this is the kind of stuff that went around, that the front lobe of the colonial subject is smaller, so therefore they are ruled by passions and not by reason, and therefore they are not they're not ready for self-governance, so on and so forth. So just to say that data and science as techniques of power has a colonial history as well. And so one of the strategies that we use is to sort of demystify both the law and break the myth of the neutrality of law and the neutrality of science that sort of feeds onto the neutrality of law, is to say that, okay, science has changed. If science has changed, then the law, which is based on that kind of a scientific assumption, for example, the two-finger test, the Hyman test, or the scientific notion of mental health, whatever colonial or coming from previous centuries, also needs to give way, so that law is based on some kind of a quote-unquote scientific rationale, which itself is not neutral. So I'll stop there.
Thanks, Aparna. Aritha, any final comments?
No, not particularly. I think we had a really good, engaging discussion, and
Yeah.
I hope that especially the audience have been able to think more about how these colonial laws affect us, and how we can effectively work our ourselves out and through this decolonization process in a manner which ensures that everyone's rights are protected and there is justice to everyone.
Thank you. Thanks all three of you. And I won't take up too much time, but as a Pakistani who's lived and worked in India and is now sitting in the UK, I'm really keen for you all to follow our regional conversations, which we will continue to have. And thank you so much to the audience also for your fantastic questions. Al-Noor, back to you.
Thank you, and just to again thank you all. I think you've moderated this discussion beautifully, Mariam. So thank you very much for that, and the whole team at iProbono, and Osama and Aparna and Arita. Thanks. I mean, really fascinating thoughts. I think we've advanced the debate quite a bit here, and of course, when you have more questions that are waiting to be asked, then that's always a good thing. But I'd like to also leave you with sort of, thank you to our own team at the South Asia Center at the LSE, especially Anya and of course Dr. Sarkar. I'd like to say also that we have a pretty interesting set of further webinars. So it is a webinarization of the world, and SAC is not exempt from that. But do tune in and watch this space, and thank you again for listening in.
Thank you very much.
Thank you.
Bye-bye. We have to stay for a bit. Okay.
Do you want us to stay on for longer, or? I think that should be okay.
Okay. Take care,
Thanks,
everyone.
thanks
Thank
both.
you.
Take care.
Good night. Bye-bye.
Good
Thank
night.
you.
Yeah, good night to both of you. Bye.
Thank you. Bye.
Thanks.